Dickerson v. United States, Supreme Court, 2000. Chief Justice Rehnquist delivered the opinion of the court. In Miranda v. Arizona, 1966, we held that certain warnings must be given before a suspect statement made during custodial interrogation could be admitted into evidence. In the wake of that decision, Congress enacted 18 U.S.C. 3501, which in essence laid down a rule that the admissibility of such statements should turn only on whether or not they were voluntarily made. We hold that Miranda, being a constitutional decision of this court, may not be in effect overruled by an act of Congress, and we decline to overrule Miranda ourselves. We therefore hold that Miranda and its progeny in this court govern the admissibility of statements made during custodial interrogation in both state and federal courts. Given Section 3501's express designation of voluntariness as the touchstone of admissibility, its omission of any warning requirement in the instruction for trial courts to consider a non-exclusive list of factors relevant to the circumstances of a confession, we agree with the Court of Appeals that Congress intended by its enactment to overrule Miranda. Because of the obvious conflict between our decision Miranda and 3501, we must address whether Congress has constitutional authority thus to supersede Miranda. If Congress has such authority, 3501's totality of the circumstances approach must prevail over Miranda's requirements of warning. If not, that section must yield to Miranda's more specific requirements. The law in this area is clear. This court has supervisory authority over the federal courts, and we may use that authority to prescribe rules of evidence and procedure that are binding in those tribunals. However, the power to judicially create and enforce non-constitutional rules of procedure and evidence for the federal courts exists only in the absence of relevant act of Congress. Congress retains the ultimate authority to modify or set aside any judicially created rules of evidence and procedure that are not required by the Constitution. But Congress may not legislatively supersede our decisions interpreting and applying the Constitution. This case therefore turns on whether the Miranda Court announced a constitutional rule or merely exercised its supervisory authority to regulate evidence in the absence of congressional direction. The Court of Appeals concluded that the protections announced in Miranda are not constitutionally required. We disagree with the Court of Appeals' conclusion, although we concede that there is language in some of our opinions that supports the view taken by that court. The first and foremost of the factors, on the other side, that Miranda is a constitutional decision, is that both Miranda and two of its companion cases applied the rule to proceedings in state courts. Since that time, we have consistently applied Miranda's rule to prosecutions arising in state courts. It is beyond dispute that we do not hold a supervisory power over the courts of the several states. Additional support for our conclusion that Miranda is constitutionally based is found in the Miranda Court's invitation for legislative action to protect the constitutional right against coerced self-incrimination. However, the court emphasized that it could not foresee the potential alternatives for protecting the privilege which might be devised by Congress or the states, and it accordingly opined that the Constitution would not preclude legislative solutions that are differed from the prescribed Miranda warnings, but which were at least as effective in apprising accused persons of their right to silence and in assuring a continuous opportunity to exercise it. Miranda requires procedures that will warn a suspect in custody of his right to remain silent and which will assure the suspect that the exercise of that right will be honored. As discussed above, Section 3501 explicitly eschews a requirement of pre-interrogation warnings in favor of an approach that looks to the administration of such warnings only one factor in determining the voluntariness of a suspect's confession. The dissent argues that it is judicial overreaching for this court to hold Section 3501 unconstitutional unless we hold that the Miranda warnings are required by the Constitution in the sense that nothing else will suffice to satisfy constitutional requirements. But we need not go further than Miranda to decide this case. In Miranda, the court noted that reliance on the traditional totality of the circumstances test raised a risk of overlooking an involuntary custodial confession, a risk that the court found unacceptably great when the confession is offered in the case in chief to prove guilt. The court therefore concluded that something more than the totality test was necessary. As discussed above, Section 3501 reinstates the totality test as sufficient. Section 3501, therefore, cannot be sustained if Miranda is to remain the law. Whether or not we would agree with Miranda's reasoning and its resulting rule, we were addressing the issue in the first instance, the principles of stare decisis weigh heavily against overruling it now. While stare decisis is not an inexorable command, particularly when we are interpreting the Constitution, even in constitutional cases, the doctrine carries such persuasive force that we have always required a departure from precedent to be supported by some special justification. We do not think there is such justification for overruling Miranda. Miranda has become embedded in routine police practice to the point where the warnings have become a part of our national culture. While we have overruled our precedents when subsequent cases have undermined their doctrinal underpinnings, we do not believe that this has happened to the Miranda decision. If anything, our subsequent cases have reduced the impact of the Miranda rule on legitimate law enforcement while reaffirming the decision's core ruling that unwarranted statements may not be used as evidence in the prosecution's case in chief. The disadvantage of the Miranda rule is that statements which may be by no means involuntary, made by a defendant who is aware of his rights, may nonetheless be excluded and a guilty defendant go free as a result. But experience suggests that the totality of the circumstances test, which 3501 seeks to revive, is more difficult than Miranda for law enforcement officers to conform to and for courts to apply in a consistent manner. In sum, we conclude that Miranda announced a constitutional rule that Congress may not supersede legislatively. Following the rule of stare decisis, we decline to overrule Miranda ourselves.